Good morning. Are you Janetta Pugh?
I am the beneficiary of that estate.
You're the what?
I am the beneficiary of that estate.
You're the beneficiary of what estate? Answer my questions, please, ma'am. I'm just trying to understand.
Beneficiary of the estate.
Okay. What's the announcement?
Judge, it's my understanding that Ms. Pugh and her family has retained an attorney on this matter. You may, I don't know if you remember, Judge, this is when I was originally appointed on, and we were on the trial docket. She hired a new attorney at that point. Mr. Norwood, who was on the case for a while and then withdrew. And once recently, when the case came back to me, I visited with her and was told that they did retain another attorney. I was given the name of Christopher Wiley this morning, but I have not heard from him. And my understanding is that at this point still hasn't filed anything with the court.
Okay.
But I've been told that that's who's supposed to be taking over the case.
Okay.
For the record, I recognize Ms. Pugh. She's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find that person as a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Pugh's behalf.
All right. So, Ms. Pugh, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact the court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that the first duty is to the state and will be considered conflict of interest.
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, two things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself, or are you going to let Mr. Lewis represent you, or are you going to hire someone?
Objection, Your Honor. Respectfully, is this a court of record?
It is a court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it, and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus, and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel to effective defense.
It's overruled.
Okay.
You're running out, aren't you?
No, it's fine.
So here's the thing, Ms. Pugh. I appreciate your position, but listen,
Respectfully, Your Honor,
Ms. Pugh, don't speak over me.
Respectfully, Your Honor, for my incarceration.
Ms. Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen to me. Everything you have there is overruled. And here's one of the reasons why, is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do. You can go back. You can go back with the bailiff.
I do not agree or comply to your appointed
Go back.
agents.
You already said that, and that's overruled.
Is to the state.
Go back with the bailiff. Get your own attorney or represent yourself if you don't like it. This is Mr. Nichols on Precious Eaglin again, y'all. Yes, sir.
Judge, I was speaking with Ms. England in the jury box, and she indicated she wanted to address the court again about the drug use.
Okay.
Okay, honestly, forgive me for not telling you the truth. Just today, I lost my mother. It'll be a year. I'm not using it as an excuse, but I've been reaching out to help out, go talk to my caseworker and stuff like that. I'm going through therapy. Like,
What are you gonna
really
test
wanted
positive?
to kill myself.
Listen, what are you going to test positive for?
For PCP. I relapsed on PCP. I've been clean. I had a sponsor. I've been cleaning out PCP for 2 years. And I just felt like I couldn't take none of this. And that's why I was asking, even out there, because I've been, my people that I'm seeing, those Saiga is out of Houston. So I had been set up everything with my son and my fiance to keep my kids. Because I really gotta give me some help. I feel like I'm on a breaking point.
All right, hang on a second.
May I inquire, Judge, how she got here this morning?
Yeah, how'd you get here?
My nephew, he outside.
Okay.
You didn't drive her.
No.
When's the last time you used?
It's been going on like a week or so. So I had to go and like detox for a couple of days. I just did it by myself so I could start taking my medication.
Where's, would you call and get, have a seat in the jury box. I'm going to have somebody come talk to you and then we'll decide what to do after that. All right? Get them back down here. Yes. So y'all were down in misdemeanor court already? Well, they'll walk him down once we go back. Let's see. Mr. Smith on Darren Carter. All right, sir, you're Darren Carter? Yes. And Mr. Carter was previously in court, entered a plea of guilty to the reduction of charge. It was a Class A misdemeanor resisting arrest. And we reset this for sentencing to give you some time to take care of some business. And have you been arrested for anything since you were here and entered that plea? Any reason not to go forward with sentencing? All right, Mr. Carter, I'm going to find, again, you entered that plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of resisting arrest, the Class A misdemeanor. Sentence you to 30 days in the Jefferson County Jail, and you will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Hold on, I'm trying to do two things at one time. I'm going to hand you the trial court certification. It shows this was an agreement that I followed, and so you have waived your right to appeal. It should be printed. Oh, I already have it. I think I printed it again. There's that. And you can go with the bailiff, and then they'll make sure he's going to need to go. Which, is it county court 2 or 3?
He needs to go to 2.
2? Okay.
Yeah.
Well, you'll make sure they can come get him maybe down there. He's in custody here for 30 days, and then he's going to go down there and do something. Thanks. Thank you, sir. Good morning, sir. You're Antonio Sanchez?
Yes, ma'am.
And Mr. Walker, will your client waive the formal reading of the indictment?
Yes, ma'am.
Take that. Mr. Sanchez, in cause number 25 DCCR 0790, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from May 25th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Walker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Hang on. I do want to go ahead and have her see what all you got, just so we have a baseline, okay? So we're going to go ahead and get that UA done this morning. So do you understand? It looks like the agreement that you've reached is for a 5-year deferred probation. There will be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sanchez is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's at that desk right there.
Perfect.
All right?
Thank you.
We'll see you back at sentencing. Thank you.
Let me excuse me.
Yes, sir. Thank you. Good morning, sir. Are you Kelton Hebert? And Mr. Hebert's charged with evading arrest or detention with the use of a vehicle in 24 DCCR 1498. And what is the announcement?
Judge, we have received the discovery and I've gone through it. It does appear that there are some recordings that were missing from the discovery that were not given to the district attorney's office. So I would like to request that from them and see if that those recordings do exist or not.
Okay.
We've had that conversation, Judge, and I'm not opposed to a reset so that we can track that down.
Okay. I'll just do a normal reset, give y'all some time to try to get that taken care of. And then, so Mr. Hebert, stay in touch with Mr. Galmore. He'll let you know when he gets that information so y'all can go over it, and we'll see if we can get an announcement at the next court date. Yes, ma'am. All right. You're free to go. Thank you. Good morning. Are you Seneca McDaniels? And Mr. McDaniels is charged with unlawful possession of a firearm by felon in cause number 24 DCCR 1915. And Ms. Holmes, what is the announcement?
Yes, Your Honor, we're trying to work out some logistics. We've gone over different ways to get this disposed of, but I think if we, by the next court setting, we will have it done. If possible, it may be reduced, but if we could get a little bit more time.
All right, so I'm going to reset it one more time.
Yes,
This will be the last one. So y'all work out what you need to if you can. If not, we'll get that announcement at the next court date. Mr. McDaniels, make sure you stay in touch with Ms. Holmes so you can go over everything with her prior to that next court date, and we'll get an announcement on what's going to happen with your case. All right, you're free to go.
Okay,
Thank you.
thank you.
See, have we seen Mr. Jeffries or Mr. Adams?
Mr. Kelly's here for Mr. Jeffries.
Okay.
Kelly's here for Mr. Jeffries.
Good morning, Mr. Kelly. On David Boyd. Good morning. Are you David Boyd?
Yes, ma'am.
And Mr. Boyd is charged with deadly conduct, discharging a firearm, in cause number 250720. And Mr. Kelly's here for Mr. Jeffries. And what is the announcement?
Your Honor, I think that there is some media, either video or USB, that we might need to get. Am I wrong about that?
Are you talking about additional media or just the media in the case?
Just media.
Okay.
Do we have it already?
I'm not sure. I thought maybe you were suggesting that there was something out there that we procured. I'm sorry.
All right, I'll just do a normal reset, make sure Mr. Jeffries gets that request in. Mr. Boyd, stay in touch with Mr. Jeffries so that as soon as he gets all that discovery, y'all can go over it and we'll try to get an announcement at the next court date.
Yes, ma'am.
All right, thank you. So, spindle talk, please. Thank you, Mr. Rojas. Mr. Lofton, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You need to speak up, please, sir. And will your client waive the formal reading of the motion?
Yes, ma'am, we will.
Mr. Lofton, in cause number 16-24485, I have a motion to revoke your community supervision. Shows that you were placed on probation February 21st of 2020 for the offense of assault family violence, and that was a 10-year term in prison that was probated for 5 years. Is that correct? It alleges you violated your probation. Count 1 alleges that you committed the offense of driving while intoxicated second on December 15th of 2023. And is that true or not true?
True.
And count 2 alleges that you failed to pay your court-assessed fees as directed. And as of December 20th of 2023, you were $5,946 behind. Is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? So I'm going to find that you enter those pleas true freely and voluntarily, find those counts true, find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing and have the probation department do an updated pre-sentence report, give me more information about what's been going on probation with the new case and everything like that, and then we'll come back at a later date for sentencing. And so you need to stay in touch with your probation officer, stop and talk to the one here in courtroom before you leave today.
Judge, it's my understanding that he's going to plead to a short jail time down in misdemeanor court. Obviously, you would have to do at least 72 hours, probably about 10 days. So he may be in custody when the update PSI comes back.
Okay,
And that is in contemplation of the fact that if the court agrees after the update, he will go to ISF as additional time.
in the substance abuse track, I would
Yes,
think.
substance abuse track with an extension of his probation, because obviously it was just told by the motion it's already
Right.
expired.
Okay,
And Your Honor, just for clarification purposes, is my understanding from talking to the misdemeanor prosecutor that we would that any time he spent in an ISF would count toward whatever sentence they assessed down the hall.
Okay, so let's do this. As soon as that happens,
Which is set on the 25th.
25th.
okay, so let's reset it just 1 week after that. Can y'all get that done in a little shorter time as on the update? It's okay. It's an update, so it's, because I also want to make sure,
So if it's after the 25th, the following Monday, we're not good, it has to be section 3.
Is there any way we could,
We might could put it on the 2nd. That's a Tuesday. If he's in custody, we could put it on that Tuesday.
do we have a docket that day? Let's do that.
I am,
September 2nd? Yes, ma'am.
I am set for trial on September 2nd in Jasper. Is there any way,
What about the 26th? Are we here?
Yes.
I'm fine with that. Of August?
Mm-hmm.
That's fine with me.
Is that okay for an update? Okay, we'll do it on Tuesday, August 26th. And that'll give you time to get that one, and then we'll need it be on a Tuesday anyway, now that I'm thinking about it, because he'll be in custody.
Right.
So, yeah, okay, perfect.
So
All right.
I need to get, for that hearing on the 26th, will I just go to the jail and do it?
They'll bring them over.
Oh, okay.
Yeah, we're bringing them over. So we'll see you on Tuesday, the 26th, once you're in custody. And we'll get
I'm
that
not going
update.
to
Not you. You're like, I'm going home. You're not out the door yet, Mr. Barrington.
Don't tell my lady.
You're free to go.
I agree with you. Thank you, Judge.
Thank you. That's number 24 DCCR 2310 on C. Andre Stevens. And are you C. Andre Stevens? C. Andre. Sorry. And Mr. Adams, will your client waive the formal reading of the indictment?
Yes, he will.
Ms. Stevens, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from October 6th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Adams?
Yes.
And do you fully understand them?
Correct.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Answer out loud, please.
Oh, yes, ma'am.
Thank you. The court reporter's taken everything down. And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Correct.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
I have to ask everyone that. State tenders number 1.
No objections?
It's admitted. Is there any evidence that Ms. Stevens is not competent?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back at a later date for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see y'all back at sentencing. Thank you.
All right.
Thank you, sir.
Thank you, Judge. Appreciate you.
Thank you.
Y'all take care.
You too.
And there it is, the final echo of a courtroom where every word carried weight and every silence spoke louder than excuses. What we witnessed wasn't just a legal process. It was a moment of truth, where choices met consequences and reality left no room to hide. The judge remained calm but unshakable, reminding everyone that justice doesn't need anger to be powerful. It only needs clarity. Each defendant stood at a crossroads shaped by past decisions, and when the gavel fell, the talking stopped and accountability began. This moment isn't just about what happened inside that courtroom. It's about what happens next, because once the court speaks, the future changes forever. The question that lingers now is simple. If you were standing there, facing the weight of your own choices, what would you have done?